Are you the successor trustee of a loved one's estate who recently passed away, and you've since discovered that that loved one's house is not in the living trust? What do you do now? Do you have to settle that estate in a formal probate procedure? Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. On this program, we assist personal representatives and probate attorneys with estate real property. So if you find this program informative, educational, or entertaining, be sure to like, share, and subscribe. Let's get started. Before I explain to you if a successor trustee has to formally probate a piece of real estate or property that has been left out of a trust accidentally, let me explain to you the common problem that occurs to a lot of us. If your house is in a living trust and you decide to refinance that house, the lender will require you to put that property back in your name. Thus, you need to remove the property from the living trust. That usually occurs when you are signing the loan docs. They are transfer documents that will remove that property from the living trust. Those documents are recorded the following day that loan is funded, and the real estate is no longer in the trust. Life happens, you forget to put it back in the trust, you pass away, and now there is a big problem. Let's avoid that problem in the future by remembering to put the property back into the trust. So, does a successor trustee have to go through a formal probate procedure with the property that has been left out of a trust? No, not necessarily. According to California Probate Code 850, the successor trustee can file a Heggstad Petition. This petition will allow the successor trustee to argue that it was the intention of the creator of the trust to have that property in the trust. If the court agrees, they will allow that successor trustee to place that property back in the trust. The Heggstad Petition seeks a court order declaring that that real property is indeed a trust asset and allows the successor trustee to have the title placed back into the trust. As a result, the successor trustee can avoid a formal probate procedure and settle the estate based on the instructions of that living trust. Question of the day: were you aware of a Heggstad petition prior to watching this video? If so, how did you hear about it and how did you use it? Let us know in the comments below. How long does a Heggstad petition take? The process can take anywhere from 60 plus days from the time that a petition is filed to the time you receive a judge's final decision. A Heggstad petition may be declined. If you've gotten value from this video, be sure to like, share, and subscribe. I'm Daryl Williams. This is Win-Win Realtors TV. If you have any questions for me, my contact information is in the description.